I want to make this video short and sweet. I'm going to give you basically 5 or 6 things that we want the Supreme Court to specifically find in this term of 2023-2024. I'm going to laser focus on just what the answers are without getting into too much detail about how the court should get there. Stay tuned. Let's talk all about what we are cheering for from the U.S. Supreme Court this year. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, I'm going to cut to the chase on this video. I'm simply going to give you 5 or 6 conclusions, findings, if you will, that we want the Supreme Court this term, which is the October 2023 to the June of 2024 term, what we want them to find, the specific things that in a perfect world, I think they will say. There'll be more that we'd like to hear from them, but these are the specific items that if we get these outcomes, I think we can consider it a very good, if not great term for the right to keep and bear arms in the United States. To begin with, let's start with the Second Amendment law itself. Now, whether this comes out of the United States versus Rahimi case, which a case involves whether or not 18 U.S.C. 922 G8 dealing with domestic violence restraining orders, if you're subject to it, you can't possess a gun during the duration of those restraining orders, even if those restraining orders go on forever. That is the Rahimi case. And then on a related case that is up for cert right now, but hasn't been granted cert, that's the Brian Range versus United States case, or Brian Range versus Merrick Garland case, dealing with 18 U.S.C. 922 G1, which is the felon in possession case, which says that if you've ever been convicted of a felony, as that is defined by federal law, which includes, by the way, people that have been convicted in state misdemeanor cases where that state misdemeanor conviction could give rise or had the potential to give rise to over 2 years in prison, that counts as a federal felony for the purposes of 18 U.S.C. 922 G1 purposes. So here is what we want specifically with the Second Amendment, and then we're going to turn to the administrative state after that. Number 1, most important thing we want the Supreme Court to say this year, most important thing by far, is the following. We want the Supreme Court to say that the government may not disarm any American citizen. The government may not disarm any American citizen under the Second Amendment unless there is a court finding after a robust hearing and ample due process that that particular American citizen is a physically violent danger to himself or to others. That's the first thing we want the court to find. That the only time an American citizen can be disarmed is if they are found to be, by a court of law after a robust process and hearing, that they are indeed a physically violent danger to themselves or to someone else. Number 1, that's what we want. Because that means the vast majority of people that have been convicted under these quote-unquote federal felonies, such as Martha Stewart, who was convicted of lying to the FBI. Isn't it ironic that the FBI and government can lie to you all they want and nothing happens, but you can't lie to the government? Doesn't seem fair, does it? But I digress. Again, that's the first thing we want. Physical violent danger is the only time you can disarm someone. If you're Martha Stewart, if you're convicted of a non-violent misdemeanor, anything along those lines cannot be disarmed. That's the first thing. On a related note, we also want the court to say, in addition to the fact that if you are found to be a physically violent danger, they can disarm you, and only in that scenario. On an ancillary note, we also want them to say, to the extent that someone is ever found to be a physically violent danger to themselves or to others, at some point down the road, it is possible for them to restore their right to keep and bear arms if they can demonstrate, let's say, or perhaps the government cannot demonstrate any further, that that person remains a physically violent danger to themselves or to others. So that's the first things we want. Physically violent danger to take away someone's gun rights, and that's the only way to do it. And if they cease to be physically violent danger to themselves or to others, they get their right to keep and bear arms back. That's the first thing. Most important thing by far. The second thing we want the court to say in Raines/Rahimi, we want the court to indicate that just like any and all other types of fundamental rights in America, the only way that they can be deprived of an American citizen is through a robust due process, which involves, at a minimum, the right to confront witnesses under the Sixth Amendment, the right to cross-examination witnesses under the Sixth Amendment, the right to a live hearing. You cannot go to prison. You cannot lose your gun rights simply on affidavits, paper. There has to be actual witnesses that the government calls at the stand that you can cross-examine. Has to be a live hearing with live witnesses. You can only be found to be a danger, right, a physically violent danger, if there is a heightened standard that's been satisfied by the state. Now, that may be clear and convincing evidence, which is the standard that people can use or the government can use to put you, let's say, involuntarily, civilly commit you in a mental health institute, or beyond a reasonable doubt, and related topics. So, again, the second critical thing we want the Supreme Court to find is that before you can lose your right to keep and bear arms, even for any period of time at all, really, there has to be massive amounts of robust due process on par with taking away your liberties, putting you in prison, putting you in a mental health institute. Any of these other things, there has to be a robust process before you lose that right to keep and bear arms. Okay? So again, physically violent danger. The ancillary is you have the right to get your rights back if at some point down the road, after being deemed a physically violent, dangerous person, you've recovered or you no longer are. And the third related thing is ample due process before those findings can be found, where you have an opportunity to have a lawyer. If you can't afford a lawyer, you have to be given one. If you can't afford expert witness to defend you, you get expert witnesses paid for by the state, which is exactly the same process that occurs in these so-called Baker Acts, which are these civil commitment statutes, which take away your freedom by civilly committing you to an institution or hospital. Same approach, as I see it, should be given here, either through the criminal justice process or at least the same level of procedure that you would be entitled to in a civil commitment process under all the basic state laws in America. Okay? That's the other thing we want. Now, so on the Second Amendment, I think those, if we get those outcomes in the Raines/Rahimi cases, we know that Rahimi is before the Supreme Court now. We're cheering for the Raines case to be brought up there and be granted cert. Whether it is or isn't, the Rahimi case can serve as a vehicle for the court to talk about these items in dealing with physically violent dangerousness as well as due process. But I think it would be better if they could take both the Raines case dealing with 922G1 along with the already existing Rahimi case dealing with 922G8, put that all together into a nice present with a nice bow on top. I think that would be the way it should go if the Supreme Court does what I think they should do. Only time will tell. And again, of course, due process, as I just went over that. Now, then we have two other cases. We have the Bumpstock case called the Cargill case out of the Fifth Circuit. And of course, we have the Loper-Bright case, which touches on the Chevron Doctrine. So on the administrative procedural side, which is really dealing with ATF authority and the authority of all regulatory agencies under the president, the executive branch, here is what we want there. In the Loper-Bright case, which deals with issues associated with fees with fishing rights and whatnot, we won't need to get into the details of what the fishermen who own these boats have to pay the government for purposes of, let's say, auditing catches. The bottom line is we want in the Loper-Bright case for the U.S. Supreme Court to say two critical things. One, we want them to say that the Chevron Doctrine is no longer the law of the land. The Chevron Doctrine is no longer the law of the land. As you know what the Chevron Doctrine says, it's been around for several decades. The idea is that when a federal agency such as the ATF opines upon the scope of its authority under its enabling statute given to them by Congress, because Congress has to pass a law that gives the ATF legal authority to act, and the determination as to whether or not they're acting within the scope of their authority is generally, historically speaking, been very deferential as to how the agencies interpret their own authority, which is kind of absurd. So basically, when in doubt, the authority is presumed, or when in doubt, the agency's interpretation of the law is assumed to be correct. This has given tremendous deference to the executive branches, and it's been abused by entities like the ATF to just make stuff up as they're going along. And because the courts, using the Chevron Doctrine, have historically deferred to these agencies, that has allowed for the expansion of the scope and powers of the presidency and the president's administrative agencies that are responsible for enforcing the law. Because as you know, Congress is supposed to pass the law, make the law. The executive branch is supposed to enforce the law. And the third branch of government, the judiciary, is supposed to interpret the law. So what's happened is with the Chevron Doctrine, you're basically saying that these executive agencies that work for the president not only get to enforce the law, they get to tell you what the law is, and the courts, instead of interpreting the law, defer to those agencies and to that interpretation. That should be a no-go, and we specifically in Loper Bright want the Supreme Court to say once and for all that the Chevron Doctrine, that deference to agencies such as the ATF, is no longer the rule of the road. It's no longer the law of the United States. That would be very good, and I think we're going to get to that outcome. Now, on a related note, and this speaks not just to the Loper Bright case, but in some ways even more so to the Bumpstock case. As you know, the Bumpstock case is before the Supreme Court. Cert has already been granted, and the question in that case is whether or not the Trump administration's Bumpstock ban, ATF's Bumpstock ban, that essentially says that a bump stock, by virtue of how it is used, converts a firearm into a machine gun, and thus basically bump stocks are machine guns. Now, this shit really is an absurd interpretation and a total overreach by the ATF as I see it, and I think this is going to be a major slapdown of the ATF by the Supreme Court. So there's two things we're going to want out of the U.S. Supreme Court in the Bumpstock case called Cargill. The first is we're going to want the Supreme Court to say that the rule of lenity is still good law and it has real teeth. In contrast to the Chevron Doctrine that gives great deference to the administrative agencies, to the president's powers, that's the Chevron Doctrine, which we want destroyed. We want that to go away this term. In contrast, we want the rule of lenity to be expanded and given teeth. But the rule of lenity says that where you have an administrative agency executive order or a regulation, if that regulation or executive order or whatever it is dealing with the executive branch, if that has the potential to put you in prison, i.e. it has criminal implications, that if you get it wrong, you hold on to the bump stock when you're not allowed to, you hold on to the pistol brace when you're not allowed to, whatever it is, if it has the possible implication of you going to prison because it's criminal related, then the rule of lenity is supposed to apply. And that goes back to the Thompson Center arms case, I believe, several decades. It talks about the rule of lenity. The idea of the rule of lenity is if there's any ambiguity with the regulation or questions as to what the regulation means, and that regulation has the potential to put you in prison, then the rule of lenity applies. And the rule of lenity basically says that in that case, the government's interpretation is ruled no-go, and the rule is to be interpreted in favor of the American citizen, in favor of freedom. Again, if a regulation which has criminal implications has ambiguity associated with it, meaning there's more than one reasonable interpretation, then under the rule of lenity, which we like as gun owners, we like the rule of lenity. The rule of lenity says in that situation where the regulation is ambiguous, then the regulation is to be interpreted by the courts in favor of freedom, in favor of the American gun owner, in favor of the American citizen, over the interpretation argued on behalf of by the government. So again, Chevron Doctrine we want destroyed, rule of lenity we want embraced and expanded. That's what we want. And the Bumpstock case and the Loper Bright case should allow us to get to those two outcomes. And last but not least, of course, we want the Bumpstock ban to be declared illegal. We want bump stocks to be found to be perfectly lawful. The ATF said these were lawful. They said these were not machine guns. They said these were not machine gun conversion kits. They said this had nothing to do with machine guns. And guess what? Of course, after the shooting in Las Vegas, the ATF did an about-face and said these are indeed to fall within the definition of machine guns. They issued a regulation that said these are machine guns, they're effectively machine guns. And again, that was just making things up. And, the only way that works is if you give great deference to the ATF, and it's pretty clear the Supreme Court, I think, is not going to allow that deference to the ATF to occur here. I think they're going to rule that bump stocks, to the extent you want to ban them, that has to be banned at least by an act of Congress. And since there is no act of Congress, you cannot ban bump stocks. I do think a decision like that will, in addition to allow us to have bump stocks again, not that that's the biggest issue on the planet, but it does set a precedent for us to be able to use in the stabilizing brace cases, as well as the frame and receiver issues, or the weapons part kits, also known as the ghost gun regulations. And by the way, as a side note, now I have not investigated the bump stock case extremely carefully on this particular point, but I have yet to see a detailed proof that Stephen Paddock in Las Vegas actually used bump stocks. You guys let me know in the comments below if I'm missing something. But my understanding was the FBI, after waiting an hour to go into the room, that's my understanding at least, there was no evidence that Stephen Paddock actually used a bump stock to shoot on the crowd. Now, I don't know if that's true or not, but that's what I've seen, that the FBI is able to show that he had in his possession a bump stock or more than one bump stock, but as to whether or not he used a bump stock to commit the atrocity in Las Vegas, I'm not sure that's occurred. And if you guys want to let me know, if you know of any evidence or any police reports or FBI reports that speak to whether or not the bump stocks were actually used as opposed to simply be in his possession, they're not the same. Possessing, in this case, is different than actually firing with it. And it's not clear to me the FBI has established that the bump stocks were used to fire. But again, you'll let me know. I'd really be interested in seeing if we have some sort of definitive proof on that factual point out of the FBI or any other law enforcement source. And again, you'll let me know in the comments down below. All right, so there you have it, folks. You know what we need to be cheering for. Physically violent, dangerous is the standard, the only standard to take away someone's gun rights. Property, before you can lose your right to keep and bear arms, there has to be robust due process. We want the Chevron Doctrine to be destroyed. We want the rule of lenity to be brought back when it comes to executive interpretation of executive orders and regulations. And last but not least, of course, we want the bump stock ban to be tossed into the trash heap of history. Those would all be, if we get those outcomes, it will be a major victory for the Second Amendment and for rights of gun owners across the United States, and a major blow to the administrative state and the size of the federal government, which I think is good for freedom all the way around. So, okay, folks, I hope you learned a little bit something here today at the 4 Boxes Diner. Make sure you subscribe and like and share the video. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.